Hey guys, welcome. This is our third live stream, and we really appreciate you being here. Let me make sure we're all on. All right, can you guys hear me? Okay, so thanks for joining us today. This is our third live stream ever. We really appreciate you joining us, whether you're live or you're watching this afterwards. We appreciate you being here. Today is Saturday, March 14th. And remember, we're going to try to do these live streams every Saturday, and we'll usually have a topic to talk about. This week we're we're really busy, and I got a lot of questions. So I actually wrote down some of the questions that we got from people throughout the week, and thought I'd just go through them. And then if you guys have questions yourself, please put them in the chat room, and hopefully we can get to them by the end of the live stream today. So the very first question that I gotta have to put on my glasses. The very first one is, what if I don't have either a will or a revocable trust here in the state of Oklahoma? Well, I've covered that in other videos, which you can check out those videos later after you finish this live stream. But simply what happens, if you don't have a last will or a revocable living trust, then what we have to do is we still have to probate your estate. So whether you have a will or not, we still have to probate your estate. Now, if you have a revocable living trust and you have properly funded your trust, which I talk about in other videos here as well, if you've properly funded your trust, then a probate won't be necessary at all. If all of your assets, everything that you have is in the name of the trust, then your successor trustee simply steps in and distributes your assets or creates sub-trusts, whatever it needs to do to carry out the wishes and the directions that you've put in your revocable living trust. But if you do not have a will, or you do have a will, either way, your estate needs to be probated. Now, I say it needs to be probated, and that means, you know, if you pass away with enough assets to actually need to be probated. We've had situations where people have come into our office, and the person who passed away was renting a house or renting an apartment. They did not own a car. And they were living on retirement or Social Security, basically paycheck to paycheck. And so in those cases, sometimes we don't have to do anything because there's literally no assets. And unfortunately, what happens if they have debts, those end up not getting paid because there's no money in the estate. So that's another important point. And actually a question somebody else brought up. I didn't think about it or write it down today. But what happens to the debts of the person who passed away? Are you responsible if you're the personal representative of the estate? And the answer is you're not personally responsible. The estate is responsible for those debts. So let's say that somebody passes away with $10,000 in a bank. A creditor legitimately has a creditor claim, and it's a legitimate claim, and you agree that it's legitimate, and the judge agrees that it's a legitimate claim. Let's say that claim was for $3,000. Well, there's enough assets to pay that $3,000 debt, so we'd most likely have to pay it. Now, if somebody passed away with $500 in the bank and they had a $15,000 credit card bill, and that's all, those $300 were all that was left in the estate because, like I said, they may have rented a house, had no car, were living on Social Security. In that case, there's no money in the estate. So I'd be surprised if we actually have to probate that estate, but if we did, there'd be nothing in there. So so what happens if you don't have anything, a will or a trust? Well, if we need to, we still have to go through the probate process, and it's going to cost either your estate or your heirs money to do that. So that's what happens. Look into our video catalog, and I go in depth of exactly what happens if you pass away without a will or a trust. So check those out. Our next question came. Yeah, this was actually at a breakfast that I was doing earlier this week. How long does a probate cost? And then somebody followed up with, how long does it cost? So how long does a probate take? How long does a probate take? Generally, in Oklahoma, we see a probate taking about 4 to 6 months. If everything goes perfectly, you're probably looking around 4.5 to 5 months. And the reason for that is simply there are statutory time frames that have to be adhered to, and we have to follow those statutory timelines. And that includes, so initially we file a petition for probate, and as soon as we file that petition, we have to wait 30 days to have a hearing for a judge to actually appoint somebody as the personal representative of the estate. And we have to give notice of that, so we have to mail notice to all the heirs. We have to put it in the newspaper. So you might have an heir who doesn't agree with you being the personal representative, so they want to come forward, and that's our opportunity, is to come forward at that hearing and say whether they agree or don't agree. It's rare, but we have seen it more and more lately, where somebody passes away and one of the sons or daughters tries to take the bull by the horns and get started right away, and the other brothers and sisters may not be ready, or there may be assets that are kind of in flux, and the probate may not be, it's still necessary, but it may not need to be done immediately, and it might be better if the heirs kind of wait a few months for the assets to get ironed out. So that happens, but so generally, because of statutory deadlines, we see probates lasting, like I say, about 4 to 6 months. If it's a big estate, we're talking several hundreds of $1,000s, it can still last 4 to 6 months. But I will tell you, if people start fighting and arguing over money and arguing over what is actually in the inventory and what's not in the inventory, it is going to take much longer. We've had several in the past couple of years where people start arguing, and anytime somebody argues, it usually has to be set for hearing. So you show up at the hearing, somebody files an objection. The judges usually don't have time because of the amount of cases that they have. They may have 18, 30 cases on their docket, and so we go to appear before the judge on the given day. And if somebody shows up to object, then the judge needs to give everybody the opportunity to state their case and state their claim and why they believe they're right or why we think they're wrong. And they're not going to have time at that initial hearing to do it. So what usually happens is it's set for a hearing, and that is usually probably 15, 30 days into the future. So right there, if somebody shows up to complain, if somebody shows up to complain and contest something that's going on in the probate process, then you can almost guarantee that it's probably going to delay the process by at least 30 days or more. So, and then there's other things that can go wrong with the probate. I've told you guys before where we had a safe deposit box that took us literally 9 months to get into. And that was 9 months after we got started in the process. It was just a bank that had some really tight rules, and that's what it took. So you just never know, but I would say generally, to answer the question, is 4 to 6 months for a probate if everything goes perfect. Now, what does it cost? That's a good question. And again, it depends on whether people are going to start showing up and protesting or contesting certain provisions or things that are going on. Obviously, if we show up and we think that at the initial hearing to get somebody appointed and somebody else shows up and says they have a better claim and it gets set for a hearing 30 days into the future, then obviously your costs are going to be higher. But generally, I probably see I want to say probably about $4,500 to $7,000 is what a probate is costing right now. And I know that sounds outrageous, which I think is an even better argument of why you should spend the money up front and get a revocable living trust so that your estate is not having to spend that money later on. If you only had, let's say as a married couple, and they had $50,000 to give to their heirs, to give to their kids, well, if we have to probate both the mother and the father, that could potentially be $14,000 or more money, right? And so that $14,000 is money that they're not getting. That's a significant amount of money that your heirs are not getting. Whereas if you were to get a revocable living trust, say, and I'm just going to make up a number here, say a revocable living trust costs somewhere in the range of $4,000 to $5,000, and you might say, well, that's a lot of money up front. Yeah, it is, but to probate the estate again, we're talking about almost $7,000, $4,000 to $7,000 to get your estate. And if you're a married couple, then you have to do that twice. So you're looking at $14,000. So $14,000 compared to the $4,000 or $5,000 to get a revocable living trust set up. You can see where you do the cost savings. And I actually have another video. I know I keep saying that, but I have a video that goes through the costs between a theoretical married couple who has a will and one who has a revocable living trust. And I think the difference came out to be $10,000 or $12,000 over their lifetime. So it can definitely save you money, and it'll definitely save you headaches, your family headaches, if you were to get a revocable living trust. And the other thing that if you get a revocable living trust, I tell people over and over again, and they're really surprised when they come into my office, is if you do have a revocable living trust and you have it set up so that it has you and your husband or your wife, your spouse, at the center of the plan, and it's set up correctly, then you guys are also going to be taken care of during your lifetime. That's the big key. People are always surprised at how many questions I have of, what do you want to happen during your lifetime if you were to become incapacitated? Obviously, we don't know. Nobody wants that to happen to us, but it could. And if you've planned for it, you're way ahead, and you avoid guardianship. Adult guardianships, guys, are unfortunately we're seeing more and more of those, and it's because people are not planning, or they're planning improperly. They're trying to do the planning by themselves. And we end up having literally brothers and sisters fighting with each other over who gets to take care of mom. Or you have mom fighting with her kids over who gets to take care of dad. And it can get really touchy. And these are really bad situations. It just never works out. Nobody's ever happy in the end. So, come talk to us or to another estate planning attorney in either here in Oklahoma or wherever you're located, and iron out these questions so that, if you were to become incapacitated or your spouse were to become incapacitated, what do you want to happen? Get those questions answered. Think about them up front. Save your family some time. Have those conversations with your family so that it just takes the stress off of them and for you later on. Because even if you're incapacitated, you still might know what's going on, and to see your family squabbling and fighting over you can be stressful and can possibly not allow you to get well as quickly or even get well at all because of what's going on. So it's just something to think about. Our next question, I hope I answered both those questions. Our next question is, this kind of goes into what I was just talking about with, let me just check real quick to make sure we don't have anybody in the queue. The next question is, what if I have stepkids and I just got married? So the couple that I was talking to, they were on, I believe, their third marriage. The husband was on his third marriage, and the wife was on her second marriage. And again, these are people that I talked to, but I'm changing the facts a little bit to hide their identities. But basically, the husband was on his third marriage. The wife was on her second marriage. The husband had kids from two of his marriages, so he had two kids, and the wife had, I believe, three or four kids from her marriage. So they were both very concerned with wanting to make certain that each other was taken care of during their lifetime. So in other words, if one of them passed away, they wanted to make certain that the other spouse was taken care of during their lifetime. And so what we were able to do with Revocable Living Trust is, actually we did a Revocable Living Trust for each one of them. So even though they were married, we did a separate trust for each one of them, okay? And we gave the spouses, we gave each other, sorry about that, we gave each other basically a life estate in what they had. So they had a really nice house that they were living in, and it actually belonged to the wife. But the wife wanted, if she were to predecease the husband, she wanted the husband to continue to live in that house as long as he wanted to for his entire life. Now, we put in provisions in there that if he decided he did not want to live there anymore, he wanted to move, then he could move. He didn't have to stay in that house, but he wouldn't be the beneficiary of any of the proceeds from the sale of that house. So we set up the house so that he could live in it as long as he wanted to, if the wife were to predecease, and if he chose to move someplace, then her kids could then sell that house and do whatever they wanted with it. But we put in pretty strong provisions that he would be taken care of if he wanted to spend the rest of his life in that house. Now, the same thing with the husband. He had assets, he had money, and so did she, to be frank. And so they just wanted to make sure that each of them, whichever one died first, that the other one would still be able to continue the life that they were enjoying at that moment and continue to live in the same style and receive whatever benefits or whatever care that they needed based on the income of both of them. But once both of them had passed away, then the estates would go to their kids and not to each other's kids. Does that make sense? I always tell people, and you've probably heard me say this in other videos, do you want your kids, your personal kids, to have your stuff, or do you want your wife's or husband, whoever one it is, do you want your spouse's new spouse, do you want them to have your stuff, or do you want your kids to have your stuff? Do you see what I'm saying there? So do you want your kids to have your stuff if you're a man, or do you want your wife's new husband's kids to have your stuff? And I think the answer is pretty clear for most people. You want your kids. I mean, you've never even met your wife's new husband, right? So the answer is pretty clear. And if you don't make provisions in your estate plan, then I have seen this happen a lot, guys, where there's a married couple, mixed marriage. And by mixed marriage, I mean that they both had kids from other marriages. The husband dies. The wife gets remarried, but they didn't make plans. So what happens was that all of the husband's estate goes to the wife. Then she remarries somebody who also has kids, and then she passes away. So her new husband gets all of the original husband's stuff. And then when he passes away, his kids get your stuff. So your kids are completely left out in the cold. So that scenario sounds crazy, but it happens all the time. I promise you. I saw that happen at least 3 times last year in 2019. So you've got to have a plan in place for this kind of stuff. Okay, our next question is, which is better, a will or a trust? Well, I think I probably already answered that in this stream, but it also depends on your situation. I really do think that a revocable living trust centered estate plan is the best way to go. It does cost a little bit more money up front, but I think if you do it and if you handle it correctly and you continue to keep it up to date, very important, you properly fund it so that all of your real estate is in the name of the trust, your bank accounts, your finances, everything that has a title is in the name of the trust. If you do it correctly, then I truly believe that a revocable living trust is the best way to go. And people say, well, I only have my house and it's worth $80,000 and I only have a small bank account. It doesn't matter. It really doesn't matter nowadays whether you have $50,000, $100,000, or $3 million. The estate tax right now, the threshold for the federal government for federal estate tax is $11,580,000 per person. $11,580,000. That means a married couple has a threshold of over $23 million. Guys, that's incredible. So really what we try to do with our revocable trust nowadays is, how do you want to distribute your assets, for one? How do you want to be taken care of during your lifetime? And so that's what we do, is we try to create a client, this is your document, a you-centered estate plan, so that it covers you now, after you leave our office, and it covers you after you pass away. So we want to create a document that is going to cover you for your entire life, and we do that by doing proper language in the revocable trust, having the proper power of attorneys in place and healthcare directives, so that we know that we have an estate plan that takes care of you now. Like I said earlier in today's live stream, people are really surprised at how many questions I have about what do you want to happen right now during your lifetime. People think estate planning is just for when you pass away, and that's just simply not true. That's a big part of it. When you pass away, you know, what do you want to happen to stuff? But the big part of estate planning is what do you want to happen now while you are still living? And we go through those questions, and they're tough questions, but if you make those decisions now, you're saving your family from having to make those decisions or having to go through an adult guardianship like I was talking about earlier. And guys, you don't want your family to have to go through that. It's a emotional and can be a very painful process. You just don't want that to happen. But there are cases that a will is the better option. And it just depends on your situation. If you know, if all you have is a house and you're living and you're retired and you're living paycheck to paycheck, in Oklahoma now we can do I can't remember the exact name, but basically, so you know, we have a deed joint tenancy with right of survivorship. So you can name somebody as your joint tenant. If you pass away, then the house automatically goes to them. Okay. You can also do a deed on death, something like that. I can't remember the name right now. But basically, you own the property your entire life. Nobody else is on the title. But when you do the deed on death, I can't remember the name. When you pass away, then whoever you name on that deed on death, they at that point get the property. So that's a very quick and easy way. If all you had was a small little house, to distribute your property to somebody. Now, even then, there is a danger in that, because what if the person that you named in that deed to get your house when you die, what if they predecease you? Then all of a sudden, that house, your house, may be going to their heirs, and you may not like their heirs, or they may get married or remarried, divorced and then remarried, and then all of a sudden your house is going to somebody you don't want them to go to. So the scenario where I see this happen a lot is, let's say it's a mother, and she has a son, and that son has grandkids, and he's married, and they have kids. So it's the mother's grandkids, and so she thinks that in order to just save money and just do a real simple estate plan, she deeds on death her house to her son, with the idea that that house will go to him and to his kids. Okay. Now, what happens is he predeceases her. The son predeceases the mother. Then the mother passes away, and now all of a sudden that house could go to his estate. Well, it would go to his estate, but if he had a will that gave it to his wife, then all of a sudden the wife gets the house. And we don't know whether or not the grandkids are going to get any portion of that, because the wife could potentially get remarried, just like I said earlier. And then all of a sudden she's remarried, and then she passes away, or she sells the house and she uses the money with her husband. In other words, just because you have an agreement with somebody that this is what you want to happen to your house, or what you want to happen when you pass away, if there's all kinds of circumstances that could come into play that could prevent that plan from going into effect. Whereas if you actually have something written that has contingencies built into it, you know that you're going to be covered. So in the case of the mother, she could have a will that says it goes to the son, and if he predeceases her, then in that case, the house could be sold and the money held in trust for the grandkids until they reach a certain age. So it's just stuff like that you need to think about. But yeah, I mean, there are times when a will is the better option. It's rare, but I think if you're a married couple, you've got kids, even if you're a single person, I'm single and I have a revocable living trust, centered estate plan. All of my assets are in my trust, and I just think that's the best way to go. But again, there are situations where a will might be the better solution, but there's not many, but they're out there. This is a question we got from somebody at a different breakfast, is do I really do pet trusts? Yes, I really do pet trusts. People always laugh when I talk about a pet trust. I've got I think 2 or 3 videos in our catalog here on YouTube about pet trusts, and you can check them out again after you finish watching this. But yeah, a pet trust is a great thing to do. We're not talking about Hollywood celebrities leaving $1 billion or $10 million to their pet. We're simply saying, I've got a pet, I've got a little dog or cat. We know that it costs us $3,000. I'm just making up a number. It costs us $3,000 a year to take care of our dog or our cat. And we know that, I don't know, I'm just making up numbers here. They're 5 years old. We know that they're going to live another 10 years. So what I would do is I would multiply that $3,000 times 10 years and come up with a number. So watch our videos on pet trusts. I think you'll enjoy them. Well, guys, that's it for today. I hope you have a great Saturday. It's kind of rainy out there today, but it looks like things are getting a little bit colder. So I hope you enjoy your Saturday. Stay safe. Wash your hands. Disinfect. And stay safe. Stay safe. We'll see you on our next video on Tuesday and our next live stream on next Saturday. We'll talk to you then. Bye-bye.